Judgment in the matter of Rukhadze and others against Recovery Partners GP Ltd and others.
This appeal consists of an invitation to this court to depart from two previous decisions of the House of Lords by softening the rigour of a fiduciary obligation generally called the profit rule. The court has therefore convened a 7-judge panel to hear it. A fiduciary is someone who undertakes to hold or to manage property for the benefit of another person or persons on the basis of an obligation of single-minded loyalty to them. Fiduciaries fall into two main groups. First, the trustees of trusts who hold legal title to the trust property, whose loyalty is owed to the beneficiaries. And secondly, certain types of agents and managers, in particular directors of companies, who do not hold title to the relevant property, but who manage and control it for the benefit of the company or other principal, and owe single-minded loyalty to them. The present case is about the latter kind of fiduciary, but the obligation of loyalty and the means whereby it is buttressed and enforced is substantially the same for both types. The profit rule is one of two related rules, the other being the conflict rule, by which the common law, or rather that part of it which we call equity, protects or deters fiduciaries from succumbing to the temptation to be disloyal to their beneficiaries or principals. The rule is that the fiduciary must account to the principal for any profits which he makes from the fiduciary relationship, unless the principal has given fully informed consent to the fiduciary keeping the profit for himself. It has existed in substantially unaltered form for at least 300 years. In addition to the obligation to account for such profits, the fiduciary also holds them upon constructive trust for the principal from the moment of their receipt. In less lawyerly language, the profits belong beneficially to the principal, not to the fiduciary. The fiduciary must reveal them, hold them for, and pay or transfer them to the principal, without waiting for the principal or a judge to tell him to do so. The profit rule has always been strictly enforced. Thus, it has been no defence or excuse for the fiduciary to say that the principal could not itself have made the profit, and has therefore suffered no loss because the fiduciary made it. Nor can the fiduciary say that, if asked, the principal would have consented to the fiduciary making and keeping the profit for himself, so that the outcome would have been no different if the fiduciary had not failed to ask for consent. And it is no answer for the fiduciary to say of his exploitation of a business opportunity about which he learnt as a result of his fiduciary position, that he could have made exactly the same profit lawfully by first resigning as a fiduciary. The law's rejection of such a defence by the fiduciary is to be found in numerous reported cases, but was most recently affirmed by this court's predecessor, the House of Lords, in relation to company directors in Regal, Hastings and Gulliver in 1942, and in relation to trustees in Boardman and Phipps in 1966. The appellants asked the court to soften the rigour of the profit rule by making it a requirement of a claim for an account of profits that the fiduciary could not have made the same profit by a route which avoided any breach of fiduciary duty. Lawyers speaking of causation call this a but-for test. Could or would the same profit have been made but for the breach of fiduciary duty? The appellants say that the profit rule, if applied without this amelioration in its enforcement, is outdated, uncertain, excessively harsh and unjust in its effect, and unsuited in the modern business environment. They say that a similar but-for test was introduced by the House of Lords as a defence to a claim for equitable compensation in Target and Redfern's in 1995, and that it's high time that the same modernisation was applied to what they call the remedy for an account of profits. This appeal is not fact-sensitive, since the appellants say that their but-for test should be routinely applied to every claim for an account of profits. Briefly, the appellants were all directors of a company or equivalent fiduciary officers of a limited liability partnership, which came upon the potentially very valuable business opportunity of providing services for the recovery of the vast hidden assets of a recently deceased Georgian businessman for the benefit of his estate. Having fallen out with the owner of the company, the appellants resolved to exploit this business opportunity for themselves, in breach of their fiduciary duties to the company and to the LLP, firstly by running down the competence of the company in their dealings with the businessman's family while still fiduciaries, and then, after what the trial judge called a resignation in bad faith, taking the opportunity for themselves by contracting directly with the family for the provision of the asset recovery services, out of which they made profits of $197 million odd. The judge ordered the appellants to account for those profits, less a 25% equitable allowance to compensate them for their time and skill. The submission now made to this court was mentioned in the courts below but not pursued, because it was common ground that the Court of Appeal would have been bound to reject it because of the binding Regal and Boardman cases. So it is actively pursued only before this court for the first time. This court unanimously declines the appellant's invitation to change this long-settled aspect of the law. I give the leading judgment with which Lord Reid, Lord Hodge and Lord Richards agree. Each of Lord Leggett, Lord Burrows and Lady Rose give judgments concurring in the result, but for different reasons, based in part upon a differing analysis of the law as it currently is. A significant part of each of the judgments, apart from that of Lady Rose, is given over to an analysis of the profit rule as it is, because that analysis forms the basis of the reasoning why the law should not now be changed. That analysis has unearthed an important difference of view within the court as to what the law currently is about the profit rule. The majority considers that the profit rule amounts to a freestanding duty to account for profits, save where consent to keep them is obtained, which arises as soon as the profit is made, and which marches hand in hand with an immediate constructive trust of the profit, binding the fiduciary for the benefit of the principal. In non-technical summary, both the duty to account and the constructive trust follow from equity's recognition of the profit as belonging beneficially to the principal from the moment when it is made. Lord Burrows and Lord Leggett consider that the liability to account for profits is not a freestanding duty at all, but only a remedy imposed by the court for some other breach of fiduciary duty, such as the conflict duty. The majority acknowledge that an account of profits can also be seen as a remedy, but that it is not only a remedy for the reason already given. Lord Leggett would go further. Whereas the other members of the court and the parties to the appeal consider that a but-for test currently forms no part of the profit rule, his view is that it already does, for the purpose of identifying whether a particular profit falls within the rule, but that it provides no assistance to the appellants on the facts found by the judge. Returning to the reasoning of the majority, it may be summarized in this way, necessarily by reference to the appellant's submissions in support of a change. 1. The appellants maintain that a softening in the remedy for an account of profits by the introduction of a but-for test would reduce the risk of harsh injustice while leaving the underlying duty and its deterrent effect in place. We consider that to be misconceived, since the remedy of an order for an account is no more nor less than the specific enforcement of the underlying duty to account, an across-the-board weakening of the remedy will necessarily weaken the duty to the same extent. But there is no basis for thinking that the long-recognized necessity for strict enforcement of the duty as a deterrent against temptation to disloyalty has receded. 2. The appellant's submission that the existing rule is out of step with changes in modern business mores is unsupported by any evidence and conflicts with the fact that large parts of the modern framework for business regulation treat the existing fiduciary regime as one of its foundations. 3. The submission that many modern fiduciaries are unaware of the profit rule, or even that they are fiduciaries at all, is unsupported by any evidence. Even if it were so, the remedy would lie in better public legal education rather than in a relaxation of the rule. 4. There is no persuasive comparison between equitable compensation for loss and accounting for profits to justify transporting a but-for test from the former to the latter. They are like chalk and cheese. 5. Notwithstanding the appellant's criticisms, the discretion to grant an equitable allowance for the deployment of the fiduciary's time and skill is a better safety valve against injustice than the erection of an across-the-board bright-line rule in the form of the appellant's but-for test. 6. The common law of England and Wales is not, contrary to the appellant's submission, out of step with other common law jurisdictions. And finally, 7. Nor is there any consensus or academic opinion that the profit rule, consensus of academic opinion that the profit rule should be relaxed. Lady Rose rejects the invitation to change the law mainly because directors' duties, including fiduciary duties, have recently been codified in the Companies Act 2006, so that any further change should be made by Parliament and not by the courts. For all those reasons, the appeal is dismissed, and the court is now adjourned.